If GST return is filed by the X person, his salary has to be the same as extended to the Y person. Even though you take the contract employee, if he is doing the same nature of work, salary difference cannot be there, and that is what is most important. Gender, but you can give the weightage of experiences, expertise. So one has to be equipped that if you are having a salary differences, you have to equip with the justification why there is a salary difference. And what is the description of work which A worker is doing or B worker is doing. And that is the work of our cost accountant to streamline those. Work of similar nature is defined as work for which skill, effort, experience and responsibility required are the same when performed under similar working conditions. And for this, we can help to the industry. Disputes as to whether work is of same or similar nature shall be decided by such authority as may be notified by the appropriate government. And for that, cost accountant can guide to the trade and industry. Amalgamation and rationalization exercises 69 from existing 111 sections. Means 111 sections has been reduced to 69. Uniform and common definition, wages, workers, employees, employers, establishment, appropriate government, all that is standardized in all the labor codes. Reduced number of authorities, tri-party boards will be implemented only one rule instead of 8 different rules. So, simplification. Hassle-free compliance options for filing and maintenance of registers, returns and form electronically. Prescribe one template for the registers and returns and forms instead of different forms in the different act. What is stated here, 76.4 million wage earners will get benefit. And who will be more benefited? Who are in the vulnerable groups within the labor market like rural, women, illiterate, construction workers, middle level education workers, casual workers, scheduled tribe and OBCs, agriculture sector workers, tiny and micro sector enterprises. All that, those my employees, my poor fellow colleagues, human beings will not be get exploited. Now let's go on the Code of Social Security. Nine acts has been combined in one Code of Social Security 2020. Employees Compensation Act, ESIC Act, PF Act, Employment Exchange Act, Maternity Benefit Act, Payment of Gratuity, Cine Workers Welfare, Building and Construction Worker Welfare, and Unorganized Worker Social Security Act. All 9 acts has been subsumed in only one Code of Social Security. Object of Social Security is, of course, extend Social Security to all employees and workers, either in organized or unorganized sector, including farm sector, mining sector, and even the household sector. Voluntary coverage under ESIC and PF scheme, even if number of employees are less than the limit specified. Social Security benefit to the temporary workers also. Definition of employee has been comprehensively elaborated to cover maximum number of employees and workers to reduce the gap. Everything is electronic registration. Even today, under various acts, now it has been done. It has been continued. Now, there will be a national security board for unorganized workers will be set up. Empower government to frame schemes for temporary workers and members of their families to cover the ESIC scheme. Social security benefit to self-employed workers. This is also a very important. And most important, fixed term employee. Now let us say that you can employ any person for 1 year, 2 years, 6 months, 9 months. And then departing is not a problem. No retracement, no layoff, nothing, all those formalities. And they will be also paid gratuity on proportionate basis, pro rata basis. Even if they work for 1 month, they will be entitled for gratuity for fixed term employee. So each and every aspect has been gone into that, and more focus on humanity and equality has been given while framing those acts. Now, ESIC will be almost available in all the districts, 740 districts of the state government of our India. Today it is only 566. And that too are not functioning. Now all 40 districts will be covered. Any establishment which is known as a hazardous sector has to be linked with the ESIC, even though there is only one worker. Gratuity provision has been made in the fixed term employee, and there will not be any condition for minimum service period for this. Fixed term employee working for determined period of a contract has been given the right of social security like a regular employee. He will get all the benefits of a regular employee. Even the same working conditions, same factory canteen he can use. No differentiation, but he will be the fixed term employee. So what is the benefit of that? You don't know. People today are engaging contractual employees for all the purposes, and contractual employees are exploited. Now, why they are not taking it? Because the retracement and layoff becomes the difficult. There is a different rules for permanent employee and temporary employee in earlier laws. Now that will not be there at all. So people used to hesitate to take the employment. Now employment opportunities will be more, and you can hire for 5 months, 6 months, 1 year, 2 years, 5 years, so that no long-term liabilities based on the demand and supply. You can face any type of situation. If your demands are more, you can employ fixed term employment more and more. If demand is less after fixed term employment, you have no continuity of the labor. You need not to go for retracement and layoff. No disputes. Let's go to the another code. Is Industrial Relation Code. Three laws has been subsumed here. Trade Union Act, Industrial Dispute Act, and Industrial Employment Act. What are the changes in that? Industrial Relation Code will apply where 300 employees are there. Earlier it was 1,000 employees, 100 employees. So small MSMEs are protected. Permission of closures and layoff will be required only when you have more than 300 workers. Otherwise, you need not to knock the doors of any factory officers, no labor officers. You can close, you can give the layoff, you can retrench anytime. Dispute related to termination of individual worker classifies the dispute in relation to discharge, dismissal, retrenchment, or termination of service of the individual worker to be an industrial dispute. And there will be industrial tribunal for adjudication. Rather than sitting with the lower officers, now there will be the industrial tribunal where the judicial member also will be present. Now what is going to happen because of that? I have given the comparison pre-labor reform and post-labor reforms. Now for each and every person who is coming in your factory, whether on the fixed term employment or contractual employment or a permanent employment, has to be issued the appointment letters mandatorily. Today, in number of companies, there are no appointment letters. Opportunity for the cost accountant to draft the appointment letter properly so that compliance of law as well as transparency, job security and fixed employment. No confusion. Social security coverage was limited in the pre-labor reforms because after 21,000, hardly there was anything. Gig workers and platform workers, household workers were never covered. Now, all workers, including gig and platform workers, to get the social security coverage, they can go and knock the doors of ESIC hospital. They will be getting the benefit of retirement benefit of PF and gratuity. Bonus. Earlier, minimum wages were on the various sectors and various zones. Now, will be statutory rate of minimum wages that will be declared nationally same. Minimum wages and timely payment will ensure financial security to each and every workman and better financial planning to the industry. Preventive healthcare. No legal requirement for employees to provide fees of annual health checkup because under the new law, after the age of 40 years, annual health checkup is mandatory. Each employee will be covered who is more than age of 40 years has to get annual health checkup and is the responsibility of the trade and industry, which will help timely preventive health checkup culture so that timely he can cure his defects if at all it is there.
नया लेबर कोड आ गया है ना आपको इसका नया लेबर कोड अच्छा हाँ
Earlier
सबको भेजा
there was no mandatory compliances for employers on payment of wages. Now there is a mandatory employee has to provide timely wages on or before 7th of subsequent month, ensuring financial stability, reducing work stress, boosting overall morale of the workers so as to, and when morale of worker is more, productivity and efficiency is more. Rejections are less. Women employment in night shift and certain occupations was restricted Rather, only in the SEZ, women workers were allowed, or for night shift specific permission, and all those things was to be there, or otherwise, number of conditions were put. Now, what is the condition? Only one condition. Women are permitted at work at the night and all types of work. What is the condition? Subject to their consent and required safety measure. You have to ensure women are safe and they are going safely at their home. Women will get equal opportunity to earn higher income in high paying jobs roles. Here also you can say Ladki sister. ESIC coverage in the pre-labor reform was limited to the notified areas and specified industries and where more than 10 workers are there. Now it is compulsory. ESIC coverage and benefits are extended pan-India and voluntarily for even though there is one worker. But in hazardous sector, even though there is a one worker, one establishment, still they have to cover under the ESIC. And this protection has been provided to all their workers as well as their family members. Compliance burden has been substantially reduced. Compensation was also covered into that. All that has gone. Multiple registration licenses and returns across various labor laws. Now, one important part is single registration pan-India. Even for contract labor, one contract labor registration will be valid for across India and one return has to be filed for that. So substantially ease of doing business and less compliance cost. What is going to be impact of that? Code by defining employees and workers differently has deprived the substantial proportion of those who practically may be doing the same work very much identical to that worker, making use of dispute resolution mechanism. Earlier, contractual workers are engaged in the production, but they are getting less paid. Now that will not be there. Scheme workers, which constitute substantial proportion in workforce, has been totally neglected by this code. The institution own or manage the organization engaged in charitable, social or philanthropical services out of the scope of industry. They should have been also covered here because when we talk equal gender, equal work, there should not be any exploitation even though they are working in charitable, social or philanthropic work. Requirement of giving 14 days notice prior to the strike and lockout. Also, in non-public utility services may help in the resolution of dispute of the third party intervention. And it will make better labor relations. So even though one day strike will not be there now without giving 14 days prior notice. No strike, no lockout with proper notice and proper reconciliation. So that issues can be sorted out then and there itself. Now let's go to the important occupational safety, health and working condition code. We have completed 3 codes, now moving to the 4th code. "13 different laws has been subsumed in one code." You see, where it was Factories Act, Plantation, Mining, Journalism, Working Journalism Act, Motor Transport Act, BD Workers Act, Contract Labor Act, Sales Promotion Employees Act, Interstate Migrant Act, Cine Workers Act, Dock Workers Act, Building and Other Construction Act. Now, all different provisions in different act has been made at one footing because every person is the same. Objective of this code is to provide flexibility and to include necessary provision in the code for enforcing rules and regulation in tune of emerging technologies. Nobody should be exploited. Broad legislative framework which enables provisions of framing rules, regulation, and standards. One registration establishment instead of multiple registrations. No separate registrations for Factories Act, Contract Labor Act, Motor Transport Act, and so called and so forth. And separate in different states. Now you will have one registration across for the India which is valid. And provision is online. No need, no interface. Team registration has been also incorporated. What are the benefits to the employers? Trade and industry. It becomes easy compliances, easy monitoring. It will help to the benefits to the companies, trade industry employees. One registration, one license, one return, one common authority across India, one nation, one tax, we said in GST. So one nation, one law in the labor laws. Single all India license valid for 5 years, no need for every year renewal for engaging contract labors. Legal provisions strengthened to make employees abide by safety norms. Heavy penalties are there, which I'll explain. Apprentices, trainees, and articles are excluded from code because they are learning. No inspector RAS, no visits, reduction of corruption. It is web-based inspection, easy and smooth process. Inspector has been changed, their role is not inspector, they are the inspector come facilitated. Role of guiding employee to ensure compliance or help them in the compliance. So attitude and approach has been totally changed rather than controlling to the helping. Now, let us read the new Indian Labor Code penalties and risk. Paying less than minimum wages, fine up to 50,000, and if 5 times repetition, imprisonment. Salary payment delayed after 7th, rupees 50,000, fine plus legal case. Gender-based pay discrimination, fine plus legal proceedings. Overtime not paid at double rate, fine plus arrears and payable. Automatically, industry will cover into the flexible wages, flexible timing. Appointment letter not issued, penalty plus inspection objections. PF not deposited and delayed, interest and heavy fine including the imprisonment. AIC applicable but not provided, fine plus prosecution. Gratuity denied, fine with payment with interest. PF and ESSC ignored on the contract labor, principal employer is liable if contractor has not deducted ESIC or not deposited with the government, contract employee's PF is not deposited, or contractual employee's bonus is not given by the contractual, all that principal employer will have to pay and bear it. Illegal termination. PF ESIC ignored by the contract employer. Illegal termination. You have to pay reinstate him and pay arrears, assuming that he is present for all the days. Standing order is not prepared. It will attract penalty and it will go to the industrial tribunal. Delay in full and final settlement. Penalty as well as it will go to the labor claim. Most important, violation of safety rules, 2 to 5 lakhs fine. And if it is continuous offense, 5 times repeated, then it is the imprisonment. Accident not reported, imprisonment and fine. Even the smallest accident also to be reported. Health checkup not done. Yearly health checkup if you have more than 40 workers. There is a fine. Missing safety for women night shift. You have not taken as much care that she has been dropped at home. Then penalty and prohibition. These are basic penalty provisions. It is simplified, but it is stricter. Now, what is the role of cost accountant to help the employers? I'll complete in my 10 minutes and then we'll open for the question answers. Set up the internal task force, which should have HR person, law person, and finance team, including cost accountant, to ensure impact. To review various aspects of labor codes and check compliances, make the new system, new employee handbook. New SOPs. Assess financial impact, because once net take home today is higher, and because of wage code, minimum 50% has to be on the total CTC, on which retirement benefits has to be there, like a PF, PF, gratuity, bonus. Then how you are going to make it? How system will be designed? What should be the structuring? And how my workers, today's workers, net home without affecting, it will come. Otherwise, when net take home goes on, there are the labor unrest. There is a reduction in productivity. So without impacting that, you have to balance both and design, and that is the role of the cost accountant to see it. Realign the component of salary in terms of Code of Wages Act. Incorporate labor codes for balance period. Now 25-26 already started, some months and subsequent years. Change the systems, update your technology, calculation of payroll, because PF will be variable. If overtime and variable commissions incentives are more. Represent to the government, to trade industry, wherever you feel these are to needs to be changed, which I'll come in later slide. And focus of all cost accountant to help the industry is 100% compliance. So you need to rework on your budgeting and cost control exercise. Gratuity schemes cap is 20 lakhs and now there will be no cap. Create the provision for gratuity. Leave encashment, because that will be also calculated as a CTC. So maximum leave encashment to encash. Now labor code has already kicked in, but rules has not come. Before that, let leave accumulation be paid off so that your PF calculation will not get affected. There is rules we are waiting for, whether that limit of 15,000 for PF deduction is there or not. That will be clear on that. But mostly that will not be there. So it will impact your wage structure. It will impact CTC because you might be deducting the PF today at 15,000. But tomorrow, if that rule provision is not there, then it will be deducted on total. So you need to revisit compensation structure. Reallocate the component considering the wage code, considering the changes in rules. Review all contracts, policies, practice, HR handbook, HR policies, payroll systems, technology, attendance monitoring system. Review the you may have to change the flexible working so that overtime payment will not come. Review of existing employment contract policies to understand the implications. Of course, government also rethink, because nothing is mentioned in the law. When gratuity calculation is there, it has to be with the prospective effect, because lot of now basic salary will go up, on which PF deductions will be more. Gratuity will be based on that. So impact on trade and industry is going to be very high. So one has to think on that. Layoff and retracement today from 100 to it has been made 300, but we should represent to the 1,000 workers so that ease of doing business, hire and fire will be easy, hire and separation will be easy, exit rule will be easy. Today there is no secret ballot system. So when multiple unions are there, there should be a secret ballot system so that no fights and it will not be there. No unrest will be there. Today, managerial and supervisor associates also coming under the overtime. And that will change the total costing of all those things. Now it has been made effective from 21st November 25 without rules coming in. So state has to think that it has to change the date, notified date. Let's see that practical difficulties. Now industry has to work on that. We have, as a cost accountant, it is our duty to help the trade and industry to be 100% statutory compliant, to balance cost, estimate future cost because of the change in the law, change the structure, improve the technology, prepare the new SOPs, prepare the new handbook, and that is the task ahead before the cost accountants. With this, now question and answer session is open so that we can think on, and I'll request each one of you to go and visit every clause on this. We have written important comments of each section in our last bulletin, which you can visit our withsoldindia.com and download. Labor code, there is a separate book on that. You can download and read on definite section-wise comments. Now with this, I leave it open to the question answer session and then to the organizer.
All members are requested to ask the questions, please.
Hello.
Yes, sir.
Yeah, this is Ashok Jani. I am having question related to this new labor code. Like earlier, contractual employees were allowed for core activities. So under the new labor code, is it true that for core activities we can't appoint contractual employees?
No, you are right. Absolutely, you cannot. Means if permanent employees, hello,
Yes, sir.
if permanent employees are working for production, contractual worker cannot be employed for production.
Okay.
So
No,
you
like
can,
some of the activities in our manufacturing plant, like loading, unloading, these some of the core activities being done by like polishing work. We are still manufacturing plant. So some of the activities are being done by the contractual employees.
no, if that is not been done by the permanent employees, then they can do it. Otherwise, not.
Okay, okay,
If
got it. Thank you, sir. Thank you.
right.
So for same activities, you can't appoint both the category of employees, like contractual as
Yes,
well as permanent.
absolutely. And if you are appointing it, same salary structure will have to be there.
Okay, okay, got it, sir. Thank you.
Nawaz, Nawaz, can you hear me?
Yes, sir.
Yeah, this particular point, the labor rules are expected. This particular point, the last point, the participant had raised.
Yeah.
Yeah, it is a slightly a gray area.
No, but it has been made very clear, sir, that
Yeah.
there cannot be discrimination.
Yeah, that's correct. But they are going to,
So,
there are some, in some industries, these jobs are being given on long-term basis, on contract basis. Because, it is a particular, they say, for example, in one is in cement. So there they said, the employers have represented where they have assured them that, please wait for the rules. That's all.
yeah. So one more part, sir. Now today there is no interfirm comparison in the law.
Yeah.
Right. So let us say in one steel industry, one person is doing the polishing activity as a permanent worker, and another company, it may be a temporary worker. So interfirm comparison is not there, industry comparison is not there. But when it says the gender differentiation which is applicable to me, I cannot do that differentiation if for that type of work, if permanent worker is doing, it cannot be given to the contractual worker. If it is given, it has to be the same pay.
हेलो
Yeah.
सर मुझे ये जानना था कि अगर कोई हॉस्पिटल है जहाँ पे एम्प्लॉइज है काफी सारे डॉक्टर्स भी कॉन्ट्रैक्ट बेसिस पे है तो उनको भी ये रूल अप्लीकेबल होंगे
अभी दो बातें होती हैं मैडम. Whether they are on contractual employees, then you make them fixed term employee.
Okay.
A. B. If they are a consultant, then you can make a retainer. So consultants are out of this. But if doctors are on employment, pardon?
Yeah.
You were saying
Hospital is signing agreement with the doctors for say 3 years.
so. It is a fixed term employment.
Yeah. But तो उनको भी अभी PF PT और 50% बेसिक वो सब लगेगा?
Yes, if they are not on the retainership basis or assignment basis. If they are charged by the per day visit, per patient, if they are paid on the per patient or assignment basis, then it will not be. But if they are on the fixed term employee, then it will be applicable. Then it will be applicable.
Oh.
Let us say one doctor visits, but he is attending, irrespective of patient, he is paid the same amount without sharing.
Okay.
Then he is a fixed term employee, even though you make a contract for 3 years or 1 year or 6 months. Then that code of wages is applicable and that 50% of total CTC has to be a retirement benefit.
Okay. Thank you, sir.
Thank you.
नवल सर, क्या आप ग्रेचुइटी का प्रोविजन फिर से एक बार रिपीट करोगे, विच वाज अर्लियर 5 years, तो अभी जो हुआ है?
Now, gratuity provision remains 5 years for the permanent employees, just like that. There is no change, except the limit, because rules will define the limit. Today is the limit. Whether tomorrow that limit will be there or not, that will decide. Rules has to come. Now there is a fixed term employee, right? Contractual employee, you have to ensure your contractor pays him gratuity. Otherwise, it will be the responsibility of the principal employer. Now coming to the fixed term employment. Now fixed term employment, it will be for 6 months, 2 years, 5 months. He may not complete 5 years, but he will be paid proportionate gratuity irrespective of years or months he has completed or days he has completed. Am I made a difference? Permanent employees, 5 years is the criteria, same rules are there. Limit will be specified in the rules. Let us wait for the rules, but most probably limit will not be there. For contractual employees, you have to ensure as the principal employer, contractual employees are also paid the gratuity. Otherwise, it will be the responsibility of the principal employer. Fixed term employee, whether he completes 1 day or 5 years, whatever the terms of employment he has completed, you have to pay proportionate gratuity. Am I made it clear difference?
Yes, sir. Very clear. Thank you.
So there is a one question from CMA Vinod Shetty. He is asking applicability of new rules will be separate for each state or single date for all state.
All rules will adopt uniform rules, but because it is we have the constitution and it is the subject of central as well as state. Central has made the act. Rules will be made by each state government, but rules will be so common like a SGST rules. It is common across the state, but different state has got implemented, different act has to amend the rules. All the legislation has made the rules. So state may have the rules, but the same provision, same form, same thing. Everything is same. No change in that.
Hello, sir.
Yeah.
Naina Manke here from Mumbai.
Yeah,
Regarding leave encashment, I want to ask there is any change in the rule because there are companies they don't give the leave encashment and the leaves get lapsed because employees don't get time to don't get the leaves because of the overloaded work and then leaves get lapsed. So is there any rule in the new code that in case of a leaves available, the leaves has to be paid in cash?
You see, based on the provisions of the Act, what is said that leave encashment will have to be paid. And now considering the change in the wages definition, code of wages, right? The impact on leave encashment will be there. Rules will say whether leave can be lapsed or it can be encashed, because so far sick leave was never getting encashed. Only privilege leave was getting encashed because the rule was there for every 21 days working, you should get 1 day privilege leave. And since you are not utilizing it, it was supposed to be paid. And it was supposed to be paid based on the retirement benefit wages, that is the on which PF is deducted. Now what the rules will be defined, that will come. Whether that will be restrictions or not, that rules what they will design, that will come. I request Venkat sir, because he has written the code very nicely in our Bitsol update and Bitsol. So Venkat sir, what is your opinion on this? Very good question by Naina ji.
Thank you, sir.
Venkat sir.
Yeah, I subscribe to your views. This is exactly what is going to happen. Because this is a slightly a gray area between companies. So whatever you said, I subscribe to it.
Yeah, thank you, sir.
Okay. Thank you, sir.
Does anybody have a question? I think nobody have a question.
What you can do is, anybody has got the question, you can write down my mail and mobile number. You can send the mail ID also. Yeah, ma'am. Yeah, Shilpa ma'am.
I have just one question. Yeah. एक क्वेश्चन ये था कि अब जैसे कॉन्ट्रैक्ट में है अगर एम्प्लॉय एग्रीमेंट है उसका कॉन्ट्रैक्ट है बट उसमें रिटर्नशिप चार्जेस या फिर प्रोफेशनल फीस लिखी है
Then
will be
he
paid
is
professional fees of
then he is not employee. He is a retainer.
okay
He is an
okay but
independent
agreement है उसका साल
consultant.
भर का in that case
He is an independent consultant, and he has to pay the profession tax as usual. It is independent number, and you are not the principal employer for him.
okay even though he is on contract for one year or 3 years
No. What is your contractual condition?
contract condition is
If you say he will just a minute. If you say he is going to work exclusively only for you, then he is not consultant. Then he is the fixed term employment. Then all the provisions will be applicable. So exclusivity has to go if he is the way consultant. But if you are saying you are only going to provide services to me and you call him retainer, by whatever the name you call it, it is a fixed term employment.
okay thank you sir
Sir, please share the PPT.
Yeah, sure. I have my mobile number is also mentioned on the PPT. Email ID is also mentioned on the PPT. But your email IDs are, I don't think I have available, so I will send it to the chapter. Then chapter can send you. Otherwise, you can do it. You can send a chat message to me. Here in the chat box, I will send the PPT.
So please share your slide once again so that I can write down
Yeah,
the email ID or the mobile number.
I'll just share it. Hey. Yeah. Sorry.
Thank you, sir.
Just a minute.
Yeah, good evening, sir.
Good evening. Email ID.
Myself, PMA Shivaji Rajmane.
Yeah.
I have some theory that most of the entrepreneurs and are not following the legal rules.
Yes.
And they are not following, they are not paying provident fund on time. They are not paying statutory pension amount. All these things they are not following. Who will be appropriate authority? Whom we
now
can,
here is only the stages has been made. Is the industrial tribunal, right? And industrial tribunal, you can say that any disputes which has been there, or you can write to the facilitator, that is inspector come facilitator. He will immediately make a case on that, and if then the case can be booked. And now today, if you do not contribute and pay to the government PF or gratuity or pension, then it is the non-cognizable offense, and punishable offense is the criminal procedure code is applied. That is the BNS, Bharatiya Nyaya Samhita is applied to that. So now,
who is the responsible authority?
Now is the inspector and facilitator.
Yeah, and non-cognizable offense, whom will be considered as a criminal?
In that is first is board of directors if it is the private limited company, otherwise proprietor or designated partner in case of LLP.
Okay. Okay. Okay, sir. Okay, sir.
Yeah.
Thank you, sir. Thanks a lot.
Hello, anyone is? Okay, now on behalf of the Pimpri Info chapter, I request CMA Prafullata Moli, please conclude the session with vote of thanks.
Thank you, Vikas
So-
sir.
Yeah.
Respected speaker CMA Ashok Naval sir, members of PCMC chapter and all participants joining us online, as we come to the conclusion of this enriching online session on Labor Laws 2025, it is my proud privilege to propose the vote of thanks. On behalf of PCMC chapter, I extend my sincere and heartfelt gratitude to our distinguished speaker, CMA Ashok Naval sir. Sir, your comprehensive presentation and practical insights on Labor Laws 2025 delivered so effectively through this virtual platform and have greatly enhanced our understanding on the subject. Your clarity, experience, and real-world perspective made this session highly valuable for all of us. I would also like to thank the PCMC Chapter Managing Committee for successfully organizing this online program and consistently bringing such relevant and knowledge-driven sessions to members. My sincere thanks to all the participants who joined us virtually today and made this session interactive and successful. Once again, thank you, Naval sir, and thank you to everyone for your presence and participation. With this, I conclude the vote of thanks. Thank you.